My gosh, I haven't seen a takedown like this in a dissent by a federal judge, maybe in my entire career. There is blood on the walls, on the ceiling. It's everywhere, metaphorically speaking, YouTube. Just no actual judges were harmed in the writing of this dissent except emotionally. It is amazing. I'm not sure I've ever quite seen a dissent like this. So yesterday, a 3-judge panel in the Fifth Circuit down in Texas, in a 2-1 decision, Federal Court of Appeals panel, decided to issue a stay against the new Texas redistricting map, one of the consequences of which it eliminated the district of entertaining Texas Congresswoman Jasmine Crockett. That clown looked like her seat was going away. But this 2-1 decision, Federal Court of Appeals said, no, we're not going to allow Texas to use its map, which would have gained the Republicans 5 congressional seats. Of course, they're going to let California go ahead and gain Democrats 5 congressional seats. But this judge decided that he was simply not going to allow this. Judge Jeffrey Brown wrote the decision for the 2-1 majority, freezing the Texas redistricting, telling Texas it had to instead use an old 2021 congressional map. 2-1 decision, 3-judge panel. So it's just a quirk in the law, by the way, folks. It doesn't come up very often. But when there's a state congressional district legal argument, it skips the normal initial court, the unelected black robe tyrannical inferior federal district trial court. It skips the trial court and it goes right to a 3-judge panel. So this is what's happened here. And by the way, this is a consolidation of cases that have been going on since 2021. So all these legal arguments started way back in 2021 when lawsuits over Texas redistricting it's been going on forever. But this came down yesterday. Jeffrey Brown, United States District Judge. In August 2025, the state of Texas enacted a new electoral map to govern elections for the U.S. House of Representatives. That's called the 2025 map. Claiming that the 2025 map is racially discriminatory, 6 groups of plaintiffs asked the court to preliminarily enjoin, so a preliminary injunction, enjoin the state of Texas from using this new 2025 map for next year's 2026 elections. For reasons explained below, the court does preliminarily enjoin the state from using the 2025 map. The court orders that the 2026 congressional election in Texas shall proceed under the map the Texas legislature enacted in 2021, which was ages ago. It was a different legislature and everything. And then he starts with a quote from Chief Justice John Roberts, which I find so ironic because the quote is, "The way to stop discrimination on the basis of race is to stop discriminating on the basis of race." But this is a redistricting case. And so it's being constrained by the Voting Rights Act of 1965, Section 2, which, by the way, is also right now being argued before the Supreme Court from the Louisiana redistricting case that I've covered with all of you before. So this opinion is being handed down by this judge at a time when he knows it's quite possible the Supreme Court is going to completely change all the rules for redistricting. In any case, because this is a redistricting case, race is always involved. The whole point of the 1965 Civil Rights Act, Section 2, the way it's been applied, not the way it was written and intended, but the way it's been applied by the federal courts, is to be race aware, to set up majority minority districts and what they sometimes call coalition district, where there's no particular race or ethnicity that's in the majority, but you can combine Black voters and Hispanic voters and gay voters. I don't know how they do it. But you build a coalition that's a majority. As long as white people, as long as white voters are in the minority, it's all good to go. The whole conception of all of this is racist. It's not race blind. None of this is race blind. And he starts off with a quote from Chief Justice John Roberts that essentially says, if you want to stop racial discrimination, you effectively have to be race blind. He doesn't do anything like that. Nothing like that happens here. So I found that notable and laughable. And I'm going to skip back a bunch of this. I just highlighted a few portions I wanted to share with you here. When I got to this point, I really LOL'd. So now, just to be clear, you're allowed to redistrict. A state is allowed to redistrict for politically partisan purposes. So the Democrats are allowed to redistrict so they have more Democrat seats. And the Republicans are allowed to redistrict so they have more Republican seats. Partisan driven redistricting is perfectly lawful, perfectly allowed. You're not supposed to do it for racist reasons unless you're supposed to do it for racist reasons to satisfy the federal courts and the Supreme Court's case law on the Voting Rights Act of 1965. But he says calls to redistrict for political purposes, which would be fine. But he starts drawing his evidence for this 160-page order. What's he using? On June 9th, 2025, the New York Times published an article. Does anybody believe that the New York Times is a reliable source of information, of facts used to completely neuter one of the largest states in the nation's redistricting plan? You're going to gut what the legislature of Texas decided to do because the New York Times published an article? The New York Times published an article reporting that, quote, President Trump's political team was encouraging Republican leaders in Texas to examine how House district lines in the state could be redrawn ahead of next year's midterms elections to try to save the party's endangered majority. Because, of course, right now the Republicans have only a slim majority in the House. Contemporaneous press coverage. So, in addition to the New York Times, this judge's decision is based on unnamed, unidentified press stories from the media, the legacy media, obviously impartial, unbiased sources of information. By the way, this is all following what's called a bench trial. So a trial without a jury in front of these three district court judges. You think any of this was subject to cross-examination? No, of course not. They didn't bring in the New York Times news article, the contemporaneous press coverage. So what they claimed could be challenged for credibility and veracity in cross-examination. Contemporaneous press coverage indicated that partisan rather than racial motivations were behind the White House redistricting. The same New York Times article reported that the push from Washington had unnerved some Texas Republicans who worried that reworking the boundaries of Texas House I don't have to read it. I just want to drive home this point. At an emergency meeting in the Capitol, shortly before the New York Times article, so it's not even the substance of the article now, it's the timing of the article that matters to this judge. And you'd think it would be really irrelevant because the meeting he's about to complain about happened before the article was published. So the article could not have triggered or influenced the meeting, but he wants to mention it. He's giving a communist fist pump. Comrade, New York Times, your name is in my mouth. At an emergency meeting in the Texas Capitol shortly before the New York Times article was published, congressional Republicans from Texas professed little interest in redrawing the districts. At the bench trial this court held in May and June 2025, when Counsel, a lawyer, asked Senator Huffman whether the Texas legislature might be considering redrawing the congressional districts. As the New York Times had reported just one day earlier, the senator unequivocally responded, they are not. So one senator in the legislature hadn't gotten the memo. Of course, they did go on to redraw it. Then this judge decides that he's going to attack the Department of Justice letter from Harmeet Dhillon. He's going to personally denigrate the executive branch's chosen lead counsel on this case, Harmeet Dhillon. The judge writes, it's challenging to unpack the Department of Justice letter, understand it, is what he means, because it contains so many factual, legal, and typographical errors. Indeed, even attorneys employed by the Texas Attorney General, who professes to be a political ally of the Trump administration, described the DOJ letter as legally unsound, baseless, erroneous, ham-fisted, and a mess. The gist of the letter, though, is that the Department of Justice is urging Texas to change the racial compositions of congressional districts 9, 18, 29, and 34. Remember, all of the jurisprudence on the Voting Rights Act of 1965, the purpose of it is to adjust the racial compositions of congressional districts. That's how it's used by the federal courts. The DOJ claimed there was racial gerrymandering. So according to the DOJ, the answer is to change the offending district's racial makeup so that they no longer qualify as these coalition districts, right? Where a bunch of minority groups are put together, whatever it takes to make sure that white people are not in the majority. And this decision continues along these lines for another 140 pages. 140 pages, which is why I had decided early on that I was not going to subject all of you to this.